the market is asking for a new take on collections. This is not an advocation for this type of collections. My intent here is to bring the information to community associations so they can do research for themselves. Personally, right now, our company uses probably 99% traditional collections for our associations. Some of the products coming on the market include no fees to the association, which you'll hear from Mitch today, and also being able to turn owners over to the credit reporting agencies, which I really feel brings a certain value, especially when we have those owners who know how to manipulate the system, and they continue to go on and on and on and cost the association thousands of dollars with no other hammer. Now, when we report them to the credit agencies, that gives us an additional hammer to get them to pay their assessments to the community association. So without further ado, let's get into the video. I'd like for you to go ahead and introduce yourself to our viewers. Tell us a little bit about who you are and what your company is.
Good afternoon. My name is Mitch Drimmel. I'm the president of Axela Technologies in Miami, and we are a collections agency. There's no nice way to say it. And we specialize in delinquent fees for community associations, condos, and HOAs. And as I mentioned, when most community associations have a delinquency, the first thing that they want to do is send it over to the attorney. And so what does an attorney do? An attorney liens and forecloses. That's not collections. That's a legal process. What we do is at no cost and at no risk and at no out-of-pocket fees to the association, we engage the owner with collection agency techniques. Such techniques are initial demand letters, letter strings, free lien notices, outbound calls, credit bureau reporting. You'd be surprised how many delinquent owners don't even know they're delinquent, don't know where they are, don't know how much they owe. It's a problem for them.
I got a phone call from a investigative journalist not too long ago. She wanted to pick my brain on a situation that she was experiencing here, which was there was a 95-year-old lady who didn't understand that she had been delinquent. There was a change of management companies, and she didn't open her mail, or she didn't, open her email, whatever it was, to be notified that there was a change in management companies. And the way that she was notified that she was delinquent was during the eviction after the foreclosure. And the lady who wanted to report on it was really curious as to why the management company would do something like that. And I had to explain to her that we're not a fair debt collection company, that we're only able to operate with collections within the documents of the association, then we have to turn it over. And you just alluded a second ago to a kind of an industry standard, which is to take a delinquent owner and turn them over to an attorney. With your model and what you're doing, do you start this process when is it that you get involved to start the process to try and help collect on the delinquent owner before it goes to the attorney? Does it ever go to the attorney in your model, or what does that look like?
The idea is never to go to the attorney.
Okay.
The idea is to resolve the issue before it has to go to the attorney. For instance, if somebody owes $50,000 and has no equity in their unit, I'm not going to be able to help you. My company cannot be able to help you because they're not going to pay, period. You might as well send it to the attorney. But that only happens nowadays. This is not 2009. This is 2020. And that only happens in very few cases. Many, if not all, homes in America now have equity in them. So you have a lot of leverage to work with them. So engaging them and not burying them deep with legal fees. When you send them to an attorney, it'll cost them $2,000, $3,000, $4,000 to unbury themselves out from what the attorney charges, because they have to pay the legal fees to get the lien released or get whatever it is released. What we do is we do what is known as a skip trace. We find out where the individual is. We call them. We send them letters. We engage with them, and then we tell them, and we've run into cases like this. Management companies change. People don't know where to send the money to or are confused. That's not really the fault of the management company. And I'll tell you why. Because if somebody's not going to open up the mail, then how are you going to communicate with them? But if you call them and you send them letters that look very official, which my letters do look official, or collection agency letters look official, people will open up that mail and see, oh my God. Also, you have cases where people are not paying, and they've paid for 10 years, 20 years, 30 years, and it's not coming out of their accounts. I understand, there are elderly people, and, I take care of my mother's bills, but still, if you don't see money coming out of your account monthly, you have to wake up and you have to proactively search the management company and say, hey, what's going on here? How come my maintenance fees are not being paid this month?
That's wonderful, and it leads me into a question. I did a video recently, and that may be where you and I picked up and started talking. I did a video on South Carolina. There is a legislator out there who is running a bill that would not allow associations to foreclose for non-payment of assessments. And inside that video that was being presented by, I think it was like Channel 7 News out there, one of the issues that was brought up by a homeowner that was being interviewed was that he has seen people with special needs and disabled people be foreclosed on within the communities and evicted. And one of the questions that I think he's addressing that he didn't address directly was non-discrimination and fair treatment, right? You as a collection agent have to treat everything the same way unless there is a requirement for some type of reasonable accommodation. Is that correct? And can you tell me a little bit more about how that works?
The ADA doesn't really overlap too much, and that's the Americans with Disabilities Act with the FDCPA, the Fair Debt Collection Practices Act. However, what your experience in the Carolinas over there is nothing new, because right here in Florida, the legislative session is coming up, and the banks are lobbying that if a community association forecloses and takes title, then the bank is the one who has a proprietary interest in the rental revenue, which is almost the same thing, which is saying, sorry guys, why bother take title? Why bother foreclose to the association? Because the only reason an association should foreclose is to get title to a unit so that they can rent the unit out and recover their money. But if the banks are coming for that money, and they are coming for that money because most mortgages have a proprietary, have language that the interest is their proprietary revenue. So in North Carolina, you're in North Carolina, you said, right?
I'm in Colorado, but I did a story on North Carolina when I saw that they were trying to introduce that bill.
In Colorado, they don't have a bill like that, but it's coming. It will be coming. They will take away the rights from community associations to foreclose, or at least, if not to foreclose, allow them to foreclose, but then grab the rent revenue. So what's the point of a community association foreclosing if you can't rent out the unit to monetize the unit after it's foreclosed? And in certain states, you take California, for instance, you can't file a foreclosure unless the delinquent unit owner owes $1,800 or more. That's in California.
Right.
And in certain states, they have thresholds, and they should have thresholds. Somebody who didn't pay a $25 late fee, and then next thing you know, they're in collections with an attorney, and they're being pursued. That's a tough thing. That's wrong.
It is wrong, and it puts a black eye on our industry when those types of things happen. And unfortunately, here in Colorado, and I think through the rest of the states, a lot of our legal system is muddied up with these homeowner association issues, specifically as it relates to delinquencies a lot of time. And I'm not sure that we're being seen as favorable as we were in 2008, 2009 time period. When people didn't pay their assessments, we won a lot. But when we went through that economic downturn, there were so many legal issues that were taking place. I think now the court systems favor us less than they once did. Would you agree with that or no?
Well, the thing is that it depends on the judge. I've been a witness in many cases, and I've had judges. I've had people come in, and I'm a witness to the veracity of the ledger. Is the ledger any good? Because the only defense a delinquent unit owner has is, here is the front and here is the back of the check, or the association didn't properly adhere to procedures such as noticing a meeting or noticing a budget meeting or something like that.
And I heard you there say association, and ultimately it's their responsibility, but I think the responsibility largely lands on the management company to guide and support them. And I really feel that there is a real responsibility for an association to hire reputable management companies that are going to follow those things through, because if they're not done correctly, it's going to be very difficult to collect on these assessments. I see them get kicked out too often when the job is not done correctly.
The management company is not responsible. These are adults because you can't sign the contract unless you're over 18. However, although I don't believe the management company is responsible, I do believe that the management company will get the blame. And the management company, the board of directors will drop a ton of bricks on your head if there's a delinquency, blaming you for some reason for poor communications or something like that. What I think that needs to be done is that there needs to be more outreach to community association members. And that's what we do, and that's what management companies do. I mean, when somebody's delinquent, what do? You send a courtesy letter, and then you send another courtesy letter, and then boom, it's off to the attorney. And try and call any attorney in Colorado or in Florida or in California and say to them, I'm a delinquent owner and I would like to get involved in a payment plan. I was sick, I missed out, my money didn't get pulled out of the bank, whatever excuses they have. They've got loads of excuses. But the thing is, that doesn't mean you have to take away their homes. It means that you've got to speak with them, you've got to engage with them, you've got to give them good reason. And then you need to work out some sort of accommodation, a payment plan, or something.
I think it was either a House bill or a Senate bill, and if I remember correctly, it was House Bill 1237, if memory serves correctly, that required Colorado to mandate a 6-month payment plan on everyone who's delinquent. And I don't know how that is in other states, but I see some value in that. It really keeps some consistency. Before there was a state law that required us to do that, we as the management company were really allowed to listen to each person's problem and kind of determine whether or not they deserved it or if they didn't. And because of that, there was a whole bunch of discrimination, not cases, but there was a lot of people saying that the management companies were discriminating. And so they kind of made it standard 6 month across the board. That's what everyone gets. And I think that's pretty fair.
Yes, and that is the law in Colorado. As a matter of fact, I do quite a bit of business in Colorado. And before I will take a unit into collections, I will ask to see, did you notice the delinquent owner that he has the ability to do a 6 month payment plan with you?
Right.
And if they didn't, I will send it back. I can't do it. I can't do collections unless that's 6 months. Also in Colorado, every community association must have a uniform collection policy. And that should be in your rules and regulations. If it isn't already in your...
It's in our policies. There's the SB 89 and 100 policies and procedures that we follow. And these collection policies is one of those procedures. And we have adopted that. In fact, we staff somebody that we call a legal liaison here that follows each association's governing documents, because as much as we'd like for every association to be standardized, they're not. Each association gets to determine a little bit about how they want to do it, and it makes it very difficult from a management perspective to follow each one of those to the letter, because we have to. And so we employ somebody specifically to perform that job responsibility for our associations. It gets complicated. These collection issues with associations are not easy, and we really do need professionals in the industry that we can rely on. And one of the questions that I have for you, because right when you started to introduce yourself and tell us about your product, you were explaining that it's a zero-cost product. And I'm wondering if the association is assigning their rights to collect on the delinquency to your firm, so you're able to collect anything that's delinquent, and that's how you're making money, or how is it that your firm is funded?
Okay, the question is, and whenever I go into a board of directors meeting, the first question is, how do you earn your money? How much money do you make? What do you charge?
Sure.
Very reasonable question. The second question, and I'll answer that in a second. The second question, and I always get a kick of it, is how long's your contract? When can we get rid of you? So first is, how much does it cost to hire?
I get the same question all the time, so let's hear your answer.
And how quick can we get rid of you? So here's my answer. Our charges are this. It's $200 for a setup. All of our charges are charged to the association, mind you, but they are passed through to the delinquent owner. So if we cannot collect our fees from the delinquent owner, we will waive off what is owed by the association to us. Okay. We cannot charge the delinquent owner directly. Any collection agency that tells you I'm charging them directly is not is acting outside the law, because the delinquent owner didn't sign up with my company and didn't sign my fees.
I'm going to jump in because we have to explain that same thing. The ACCU, we as a management company, our contract is with the corporation, which is the association, not individual member that lives in that association. Now, through our contract, we are able to try and collect from that owner, but we can't mandate it. So we do have to collect that money from the association, who our contract is with, and then if the owner pays, they get reimbursed. So what you're saying for your company is it works the same way, but that if you're not able to collect from the owner, that there is no charge to the community association. Am I understanding that correctly?
Exactly. Okay. Now, our fees don't stop at $200. What it is, the $200 is the setup fee. And the setup fee is for doing a whole bunch of underwriting. We do what is known as a skip trace. We look at the property appraiser's site. We do the court to see if there's a mortgage. We do a very large algorithm to see if there's equity in the unit. And then when we get it all ready, we send out the initial demand letter saying to the owner, you're delinquent, you owe this, please make a payment. If not, you could call us or you could log into our portal. And if they don't want to speak to somebody, they could actually work out a payment plan online or make a payment online, or resolve it online, or speak to somebody if they want to dispute what they owe. If they believe that they owe less than what we're showing them, then we're sending them a ledger. So let's say you send somebody into collections. My company will take the ledger and maintain the ledger. Every month we add the maintenance fees, the late interest, the collection costs, and if you have fines and violations or special assessments, we'll add that on as well. And we do the ledger maintenance. And so if somebody calls you and says, what's going on with my ledger? Why are you in collections? Why am I in collections? He said, well, first of all, we tried to contact you. We sent you letters and it didn't work out. So we sent you to collections, but call this number. So our customer service representatives are familiar with this type of debt. And we hear very similar stories very often. New management company came in. I had automatic withdrawals. All of a sudden, the withdrawals weren't coming out of my bank. All sorts of stories. And then you hear some heartbreaking stories. And then you hear stories of people who are just trying to game the system. And you get a lot of that.
I mean, we as the management company, our hands are tied because we are not a fair debt collection company. We cannot get involved after it's turned over to a collection company. Our hands are off, right? So there's not a whole lot that we can do, and the collection companies are really restricted to certain laws within certain states. Do you want to take a moment to kind of address that and how boards should really view these delinquencies when somebody knows the system well enough to get away with it?
Right. Well, first of all, we are bound by federal laws, the Fair Debt Collection Practices Act. The FDCPA, you've heard it, everybody's heard it. We're bound by the FCRA, Fair Credit Reporting Act, because one of the things that we do, which lawyers don't do, is we will report people to credit bureaus, and we will present consequences for non-payment. And we are also have to be licensed in each and every state that we're in. And we have to be very careful about how do we speak to people. It even gets even more serious. We have to be more careful on the fonts and the colors we use in our demand letters. We can't make them look threatening. Now, for people who are going to game the system, there are those people out there. And one of their favorite tools is bankruptcy. Okay, bankruptcy doesn't last that long. A lot of people think bankruptcy is a 5-year process. Bankruptcy shouldn't be any more than a 9-month to a 1-year process.
If you know how to work the system appropriately.
Right. I mean, it is a difficult thing, but let's say you gave me a unit that filed for bankruptcy or is in bankruptcy. Okay, that's fine. What I'm going to do is get the ledger, keep the ledger, split the ledger in two. One is pre-petition, the other one would be post-petition. And then what I'm going to do is once a month on a thing that I have called PACER that lawyers have, and we have in-house attorneys here that work for us, they don't work for you. We will check to see if that bankruptcy has been discharged. And once the bankruptcy is discharged, and we check it out once a month, in Florida, we have what is known as the DBPR. They're the division for condominiums and condominiums, timeshares, and don't tell me, mobile homes.
Okay.
And what they'll do is they'll put in complaints, and they'll say the association never had a properly noticed budget meeting, or the association did this wrong or that wrong or procedurally wrong, and it's an illegally appointed board. What we simply do is we straighten them out. We tell them the association did have, and we will go back and check on it, because I've been to court where an association has tried to foreclose on a unit, and they use that defense that they didn't properly have budget meetings or elections or something like that. And the judge will say, no, this condominium is not running itself properly. I'm afraid that we're going to have to give these people a break and no judgment on behalf of the association. And what does that do? So now the association has lost money on maintenance fees, and you've lost money on attorney fees because you've lost. I mean, I've walked into associations that haven't had a proper budget meeting in 5 years. So people know about these things, and if the association isn't properly run, and I find this, and I know you're going to be happy, these are going to be music to your ears, but I find this happening in self-managed associations. People who wake up one day, get elected to a board of directors and say, what do I need Phifer for? Or what do I need this guy for? Or what do I need that? Only to find out later that it's a mess without you. And that's how they play the game.
There are certain states where it really is the Wild West still. There will be a motion from the floor to adopt a policy in the community that is blatantly illegal, and it'll be ratified unanimously within the association. It's just crazy. And what it comes down to is additional education, something I'm a huge advocate for and really trying to do with these videos. And, your involvement is certainly appreciated. If there is a homeowner who is asked to be a part of their board and they go to YouTube to do some research to find out what it's like to be a board member, they probably will run the other direction because there's not enough content out there that helps educate people as to what it really is to be on the board of a homeowners association. And I think the same thing for managers. It's just people going with their cell phones and filming absolute nightmare community meetings, and it's the worst of the worst, and that's not the way it always is. There are some communities that are very well run. We're advocates for the association, and most communities pay their fees. I mean, most of these communities, adults live in them. Right? And I think you alluded to it before. The people who don't pay, there should be a consequence, and everyone's got a sob story. And I get it. And some of them, when they're honest, I think the board and the attorneys and the collection agencies really come to the rescue and come up with good payment plans if they're being honest. But if they're just trying to come up with a sob story to get out of paying, then that's not the fault of the association. The other members shouldn't have to pick up for their slack.
One of the downfalls or one of the bad sides of this particular industry, and I'm getting off collections a little bit, is that there's a lack of consistency. New board of directors is elected and everybody gets fired. So I'll walk into a board of directors meeting and I'll sit down with the new board of directors, and they're the third board of directors in 5 years, and they've been through 4 management companies. The record keeping, the records from going from one management company to the other management company to the other they don't have any records. And in every state of the union, I know this because I'm a licensed community association manager and I'm a professional as a manager. You must keep the records for a certain amount of years, either 5 years or 7 years, all the records. And I'm talking about even the ballots from the election have to be kept for 1 year. The ledgers are the ones that suffer the most. I receive ledgers that have balance forward. Now, if I have a ledger balance forward, I can't collect on something that's balanced forward. It doesn't show. And no attorney can collect on something that's balanced forward, although attorneys don't collect. What an attorney will tell you to do is to carve that out and let me foreclose on the money that I can prove wasn't paid. Does that make sense to you?
It does. And for the people who are watching this video, a balance forward really happens when a community switches from one management company to another. Is that correct? And one association will show the balance forward to the other?
Yes, but they won't give a historical ledger.
And so that ledger becomes compromised and you can no longer collect on that balance because of improper information. So what an attorney will do is it'll take the information that is fair and accurate and try and foreclose on just that information. And that becomes sticky and sloppy.
Well, it also becomes a loss to the association because let's say they live in what is known as a super lien state and somebody owes 6 months and the bank forecloses, and they've written that 6 months off, well, they lose that 6 months of maintenance fees.
The way that I understand it here in Colorado is that the bank has a priority lien on the unit. So the association is subordinate to that lien, meaning that they cannot collect above the mortgage holder except for 6 months. So upon foreclosure of a unit, the association has a right to 6 months worth of the current assessment rate.
Up to the time that it was foreclosed. And it depends on the state. And in Florida, it's the lesser of 12 months or 1% of the first mortgage. In Colorado, it's 6 months. In New Jersey, it's 6 months for every 12 months up to 5 years.
Well, can we have that in Colorado too? Because that would be fantastic. Wow, is Jersey really that? Wow.
Jersey just passed that. Jersey has it going. So they've got a big super lien. Only 27 out of 50 states have some sort of super lien laws so that when the bank forecloses, the association will get something, but it's usually a fraction of what they're entitled to get.
Let's just use Colorado as the model because it's pretty standard, 6 months worth of assessments. Does Axela take any of that super lien amount, or does 100% of that go to the association?
100% of the principal goes to the association. If we cannot collect, and again, let me review my fees, because I started to before. It's $200 to say hello, to get set up, and then it is the equivalent of the late fees and the late interest that you're allowed to charge in your governing documents. So if you're allowed to charge $25 a month or 18% a year, that equivalent, the late fees and the late interest, is what pays us. And that's what they're for. The late fees and the late interest are for that purpose, to cover delinquencies and to cover the cost of delinquencies. So that's what we charge to the delinquent owner. And again, if we cannot recover it, we don't expect the association to pay it back. Now, if the bank comes, forecloses and takes title, and gives the association 6 months, that principal belongs to the association, we take a loss. If you have taken that unit and given it to an attorney, and the bank comes and wipes out the first lien, their lien, and the association's lien, the bank will of course give you 6 months, but the attorney will grab that 6 months, and then you'll still owe the attorney more because you had an attorney working on the case for a year, 2 years, and they will require to be paid. And probably you've already paid them as you've moved along.
Right.
And there's a big loss for the association. It was a race to the courthouse steps. The banks won. And even if had the banks not won, let's say the association was able to foreclose before the banks, and the association had the right idea to rent out the unit to monetize the property, correct?
Right.
Well, 3 months later, the bank's going to come and foreclose and get a judgment on it and take title. So you've just wasted all your money on legal fees. You've wasted all your money on rehabilitation of the unit, marketing the unit. Maybe you've never even got. So it doesn't make any sense for associations, and I keep saying this over and over and over again. Unless somebody is stone cold not going to pay, it makes no sense for the association to foreclose on a unit. You must go through the process, and the process is this. Let your management company send those courtesy letters like you do. And by the way, those courtesy letters, and this is for managers, you really should not put them on your own heading, on your own paperwork. Put it on the paperwork of the association. And sign it for the board of directors, because there's been some case law where management companies have been considered collection agencies because they're
it's on their letterhead, and so they're seen as the collection agency.
Exactly. They're not the collection agency. They're the first credit creditors. They're the first party creditors. So that way, they cannot be guilty of any violations of the Fair Debt Collection Practices Act, whereas a management company can be.
That's great. That's wonderful information. Let me ask you a quick question, because I've had some success with this model in the past, and I'm curious if you as a collection company have done this or have thought about it. With some collections here in my market, what we have done is we have gone to the bank and we have gotten the information on their loan, and we find that it does state that the lender can pay assessments. So we go to the lender and we explain to them that they should pay now because they're going to owe 6 months of assessments anyway. They pay the assessments and tack it onto the back end of the loan for the homeowner. So now they're dealing with the bank instead of us, but now we've been paid. Is that a process that you hear about, something that you're interested in doing? Is that even a model that can be done? How does that work?
That's a model that we automatically do. We do that as a matter of course.
Okay, great.
We notify, and remember I talked about our underwriting. We find out which bank has the mortgage for the association. Okay. And then what we do is, by virtue of what is known as a PUD rider, planned unit development rider, or a condo rider, we are allowed to advise the bank that holds the mortgage, or the servicing company, the mortgage servicer, that this guy is late. Banks don't like it when you don't pay insurance, taxes, and maintenance fees. So one of the things that we do, one of the very early things that we do, is we rat them out to the banks, and we find out who their banks are, and we tell the banks, hey, these folks aren't paying their maintenance fees. The banks get very rattled because they don't want anything complicated in their collateral, in their property. So the banks will, in certain cases, pay us, add it on to the mortgage amount, right, and collect it from the delinquent unit owners, just as you explained. And that's by virtue of the rider, called a PUD rider, planned unit development, or a condo rider.
That's exactly right. That's great to know. So being as we're running out of time here, I'd like, if you could, just give us a quick little elevator pitch on what your company is and why choose you for the collection of assessments.
Okay, very good. What I'm asking people to do, boards of directors and members and managers, is consider a collections process over a legal process, is what lawyers will do. There will never be a case that a lawyer will walk through that door and come in, that you walk through. No, I can't take that case. There will be in mine. There will be the guy who owes $50,000. He'll never voluntarily pay. Okay? That should go to a lawyer. But there should be a process, a collections process involved before you go into a legal process to take away somebody's home. And if it costs you no money and it's at no risk and no danger to the association, it's a beautiful, brilliant way to go about business. And we do not bury the owners in fees that they can't pay. Our fees are very reasonable. They're, like I said, $200 plus the late fees and the late interest, something that they're not unusual with. And we do a lot of work. We reach out, we call, we connect, we send letter strings, we speak to them, we report them to credit bureaus, we notice them to the banks, and we will also cause an attorney to file a lien. We don't like doing legal stuff, but filing the lien is an important thing along the process. But we tell the attorney, you're not doing collections here. We're doing collections here. We're filing the lien, protecting the interests of the association. Again, it works. And right now we've signed up. We usually sign up management companies. We don't go wholesale association by association. But if any individual association wants to, please call and we'll send you a contract. We sell our product, our service, through management companies such as yourself, whereas you can absolutely offer fair debt collection practices services to community associations. And that's how we work.
I love it. That's great. I can't tell how much I appreciate you taking the time to speak with me today and give education to this industry that I think means so much to us both. I really value what we do. I think we bring a lot of value to community associations and boards, and I just think we need to do a better job at trying to educate and get ourselves out there. So I appreciate you doing that today. I did receive your marketing information on my desk here in Colorado, so you're obviously getting some reach all the way from Florida. Good work.
Yeah, I'm trying. I've got a good marketing team, but I'd like to tell people that I am involved in Colorado. I know the laws. We have a 95% success rate, and that, to define that, means 95% of the files that are sent to us, we recover 100% of their money, and then we have to kick back 5% and say, look, there's nothing we can do. Take it to an attorney if you want to, or don't invite the guy to the Christmas party next year. What can I do?
Yeah,
Yeah, that's it.